Chapter 12, Leases. Let's talk about this. Okay, so what will we be able to know after the end of this chapter? Okay, we'll be able to explain the characteristics of the leasehold estates, or what we also call our less than freehold estates, right? Because we were talking about freehold estates are types of ownership interest. These are what they categorize as less than freehold estates or leasehold estates or leases. Okay. You'll be able to describe standard lease provisions, including various forms of eviction. You will also be able to discuss the differences between the various types of residential and commercial leases. Okay. Now, let's talk about what a lease is. Okay. A lease is actually taking the rights of possession that are in the bundle of rights and ownership of real estate. Remember we talked about that, chapter 5? Bundle of rights. One of them is the right of possession. Owner has the right of possession. So what a lease does is it transfers the right of possession from the owner, who now becomes the lessor. OR gives, okay? Lessor is the one giving the lease to the tenant who is receiving the lease. Lessee receives for a specified period of time. This also is referred to as demise. Demise. Demise is to transfer of property by lease, okay? Devise, if we change one letter in that, is to will real property. So when you're devising something, you are willing real property. So a lease is unique because it is both a contract and conveyance of that right to possess the property. So let's talk about our different types of leasehold estates or less than freehold estates. The first one is an estate for years. Now let me tell you what the litmus test is for an estate for years. The litmus test is that is a definitive period of time. There is a specific beginning and there's a specific ending. Okay, so every year I go to Ocean City, Maryland. We rent a condominium for 1 week. Okay, is that an estate for years? Heck to the yes. An estate for years just has the litmus test of having a specific beginning and end. Okay. Now, what's nice about this is that there is no advance notice to end the lease because the lease just ends. Okay. So what happens is they give you a funny question on the test. First, they'll say, tenant has a 1-year lease, right? Tenant has a 1-year lease. Okay. How long do they have to give? How much notice do they have to give to end the lease at the end of the year? No advance notice. And that is an estate for years, okay? That is an estate for years. If there is a definitive beginning or end, there doesn't need to be any kind of termination given. It will just end on its own. Now, the next one is a periodic estate. A periodic estate. A periodic estate is from one period, a predefined period, to another predefined period. So it auto-renews. Okay, so the difference between an estate for years and a periodic estate is that a periodic estate auto-renews. Some people refer to the most common form of a periodic estate as a month-to-month lease, where it automatically renews after the 1 month, and it goes on in perpetuity. Okay, now periodic estates can be canceled by either party, either the lessor, the landlord, or the lessee, the tenant, okay, can give notice to quit. How much notice do they have to give? Great question. They have to give 1 period. Whatever 1 period is, you could have a year-to-year, you could have a week-to-week rental. It's not that it has to be for a specified time. It's just that it has to renew itself from one period over the next. So that is what is referred to as a periodic estate. Periodic estate. It's right in the name. It's periodic. It's one period to another, auto renews. Okay. Now the last 2 types of leasehold estates is a tenancy at will. So tenancy at will is an indefinite period of time. However, However, in order to end it, they must give 3 months notice. Okay, this is interesting about this one. So it's for an indefinite period of time. Indefinite period. Tenancy at will is usually the tenant uh, had a lawful tenancy. Okay, and now they're usually like a legal holdover, or it's something that it could also be created by just saying, hey, would you like to rent my property? Sure. And now here's the difference. Tenancy at will has no definite period. It's an indefinite period of time. So what happens is it could be broken down that it doesn't auto renew. Okay. So a lease that doesn't auto renew, so period to period, month to month, auto renews at the end of the month, right? For another 30 days. Okay. This one could be, hey, you can stay here until you get back on your feet. Okay. But you have to give the tenant 3 months notice. Also, it is terminated by the death of either the landlord or tenant. Okay. Now, tenancy at sufferance. Tenancy at sufferance is originally a tenancy was lawful. Okay. Tenant holds possession without consent of the landlord. They are a holdover tenant. They are an illegal holdover tenant. Tenancy at sufferance is an illegal leasehold estate. Okay. You do have an interest in the property. You do still have possession, but what happens is this: you do not have lawful possession of the property. You came into it. The original tenancy was lawful, okay, but the holdover possession is not, okay. Tenancy at sufferance. Now, a typical lease will give you use of the property for however long the term of the lease is. Now, one thing that you have to also know that anybody who's working with you in a rental capacity, they still need to be given the consumer information statement. They still need to be given that, which outlines the ways in which we can work with a client in the state of New Jersey and the ways in which we intend to work with a client in the state of New Jersey. Okay, so that is an important piece of information that you still have to do. You still have to identify the business relationship that you intend to have with either that potential tenant or that potential landlord. Okay. Same thing goes as for sales. So rentals, same deal here. Nothing changes. Also, when we're talking about lead-based paint, if it's built before 1978, a tenant must get a lead-based paint brochure, and they must sign a disclosure statement understanding that there's either reports and knowledge of lead-based paint in the home, or there are no reports that the homeowner has of lead-based paint in the home. Now, another thing that we're going to talk about is this: security deposits for residential properties. It's residential security deposits. People love to do this. Landlords love to put a pet security deposit. So what they'll do is they'll take a month and a half rent, and then they'll take a pet security deposit if you want to have a pet of maybe $300 to $400 to potentially clean or repair the unit if need be, right? So that is a pet deposit. Is that legal? 1.5 months rent and a pet security deposit. The answer to that is no. Okay, they could charge a fee, they could raise the rent, but they cannot take a deposit which exceeds 1.5 months rent. So they can take 1 month rent and then take a pet security deposit as long as it does not exceed 1.5 months rent. But as soon as it exceeds 1.5 months rent, that is illegal. Now, also, the security deposits must be held in a bank account that is a landlord tenant account. And at the end of the year, that tenant needs to be given the interest on these security deposits. So you need to have the interest given to the tenant for the security deposits. A lot of people don't know that. A lot of landlords who are not in the know in regards to how to run a successful real estate rental income business, they might, and it could be innocent misrepresentation of themselves, where they are oblivious to the fact that they have to do that. Some landlords do it, like I said, unintentionally. So that's something that you have to be aware of when you're advising and helping landlords in regards to collecting security deposits and advising them of such. Okay. Now, Americans with Disability Act. So, Title III prohibits discrimination in commercial buildings. Now, this is something that some of you might deal with, some of you might not. But it recommends that there's always going to be reasonable accommodations to full and equal access to facilities. And this is for commercial buildings, okay? This is for commercial buildings. Also useful to consult ADA experts and architectural designs. Again, I just left this in here because this was something that I thought you might want to read up about a little bit. Your book touches on it a little bit more, but that's about all you need to know about it. Now, let's talk about eviction, okay? Let's talk about eviction for a little bit, okay? There's two types of eviction. There's actual eviction, okay? Or there's constructive eviction, okay? Construction eviction is interesting because it's actually not the fault of the breach isn't on the tenant's part. That's what we think of when we think of eviction, which is suit eviction for possession, which is the second bullet point. Okay, that's actual eviction. That's when the tenant breaches. Okay. When there's constructive eviction, the landlord fails to provide some basic services. So let's say the bathroom's not working. There's only one bathroom in the home. Then basically what happens is if it's not done in a timely fashion, that things are repaired, things are remediated, things are handled, then the tenant must vacate, move out, stop paying rent, and they could file a suit for constructive eviction if the landlord fails to provide basic services. If you were going that route, you must vacate, move out, stop paying rent. Okay? But again, these are two very different ways to evict someone. So causes for eviction. Non-payment of rent. I think that's a common one. And this is actual eviction. Tenant's disorderly conduct. Destruction due to tenant's gross negligence. Tenant continues to violate landlord's regulations if included in the lease. And there's also many, many, many more ways, but they like to go over these couple of things. Next, we're going to be talking about commercial leases, leases for commercial properties. You really want to kind of get the 10,000-foot view on these, and I am going to provide that. So, gross lease. Tenant pays a fixed rent. Landlord pays all the taxes, insurance, mortgage payments. This is what you would consider walking, talking, eating, breathing, and sleeping. Regular standard lease. Okay, if you're renting a retail space and they're like, sure, just give us $1,000 a month. Landlord's paying taxes, insurance, mortgage payments, things like that. Net lease. Net lease. Tenant pays rent and some or all of the property charges, including taxes, insurance, mortgage payments, repairs, all that kind of stuff. Now, why would someone want to do that? Why would someone want to say, hey, we'll take care of all those things. Don't worry about it. I'll tell you why. It's very simple. Big chains. What's the most recent one to go out of business? Sports Authority. Yeah, Sports Authority. So Sports Authority has thousands of stores across the country. There are tax benefits to owning the real estate. However, they couldn't just quickly close the doors if they needed to. Now, when it comes to their rents, they're probably set up as net leases, or also there's triple net, 7 net. I will not get that fancy with you guys yet. And what happens is those tenants like Sports Authority, Best Buy, they'll pay the rent and all the things, okay, because they want to have some sort of tax benefits, write-offs, things like that, even if it's very, very little. And also, they get all those beautiful benefits, kind of similar to ownership, but they do not own the property. So when they do, when and if the time comes that they either need to liquidate, close stores, or do anything of that nature, it is very easy for them to do so. It is very easy for them to do so. Now, next one that you're going to see is a percentage lease. Percentage lease. What's a percentage lease? Great, you asked. A percentage lease is usually strip malls, shopping malls is really the most common you'll see percentage lease. They have a rent, which is the standard. Then what happens is you will see there's also tacked on to the rent a percentage of the gross income, and it varies due to the nature of whatever business it is. There's some that have leases that are huge, massive leases, like pharmacies have massive leases because they have to write up every single SKU and drugs and prescriptions based on what insurance company is paying what. It's really, really complicated and convoluted. But what I want you to know is that is what a percentage lease is. The other ones you can read about in your book, they're really not as important as the three that I just went over, which were your gross, net, and percentage leases, which are your commercial leases. But that is all she wrote for chapter 12. Again, if you have any questions, let me know. If not, have a great one.